Uganda Road Criminal Service number 87.4 and 91.4. Isaac Ssemakadde, the applicant, versus Uganda, the prosecution, ruling by Justice Kadena Paul Walingwa. I'd say a ruling of 40 pages, and I'll pronounce all the salient features of the ruling, and thereafter parties will access the ruling with the federal judge immediately after something delivered. Number one is whether this application for stop proceedings is premature, misconceived, and incompetent. In their submissions, the respondents raised a preliminary objection that the present application for stop proceedings is immature, misconceived, and incompetent, as there are no proceedings in the lower court capable of being stayed, because proceedings in a criminal trial only commence upon plea taken. They urge that the applicant in the present case has not yet taken a plea in the Uganda Court Criminal Case number 913 of 2024. He repeatedly failed to comply with criminal summons on 2 occasions, which led to the issuance of an arrest warrant on February 24, 2025. Consequently, no trial proceedings have commenced, and nothing before the lower court can be stayed. Additionally, the respondents argue that the law does not permit an accused person to disregard court summons, fail to take a plea, and spiritually seek to hold proceedings that have not yet begun. Entertaining the application under such circumstances would amount to an abuse of court process. For these reasons, the respondent prayed that the application be struck out as premature, misconceived, and incompetent. A private prosecution is a judicial process in which an individual with probable and reasonable grounds to suspect that another individual has perpetrated a criminal offense endeavors to have that individual formally charged and summoned before the court. Section 42, Section 2 of the Municipal Act provides that any person other than a public prosecutor, a police officer, who has reasonable and proper cause to believe that an offense has been committed by any person may make a complaint of the alleged offense to the magistrate, who has jurisdiction to try or inquire into the alleged offense, or within the local limits of whose jurisdiction the accused person is alleged to reside or be. Every such complaint may be made orally or in writing, signed by the complainant, but if made orally, shall be reduced into writing by the magistrate, and when so reduced, shall be signed by the complainant. According to the above section, criminal proceeding in a private prosecution are deemed to have commenced when an individual who is not a public prosecutor or a police officer submits a complaint under oath regarding an alleged offense to a magistrate with appropriate jurisdiction. In this case, Criminal proceedings against the applicant commenced when the respondents filed a complaint under oath with the chief magistrate. Therefore, it is incorrect for the respondent to assert that there are no proceedings in the instant case that merit consideration for revision. This finding thus discloses the preliminary objection. Issue 2. Whether criminal case number 913 of 2024 should be stayed pending determination of the revision court number 2 of 2025. The applicant submitted that the court should stay proceedings in criminal case number 913 of 2024 pending revision because 1. He established a prima facie case that is neither frivolous nor vexatious, and the matters raised therein have the probability of success. Secondly, he will suffer irreparable harm and prejudice if he undergoes a trial vitiated by fundamental flaws and irregularities in the alluded to in the application for revision. Thirdly, the balance of convenience favors the applicant because failing to stay in the proceedings would violate his civil liberties. In opposition, the respondent argued that the application for a stay should be dismissed for being unfounded and an abuse of court process because, firstly, the applicant had failed to establish a prima facie case that warrants the granting of injunctive relief. The Chief Magistrate acted within jurisdiction under Section 43, Subsection 3 and Subsection 7 of the Magistrate Court Act in entertaining the respondent's complaint or oath, and there is no evidence of illegality or miscarriage of justice. Secondly, the applicant failed to demonstrate that they will suffer any loss or injury that cannot be compensated through monetary damages, nor have they shown that such harm is difficult to quantify. Thirdly, the balance of convenience does not favor the applicant's request for a stay in criminal proceedings. Further, the respondent submitted that the continuation of their legal rights and the proper functioning of the judicial process would be severely hampered by the imposition of a stay of proceedings. Additionally, the respondent submitted that the harm to the respondent includes not only the obstruction of their right to pursue legal remedies, but also the broader implications of the integrity of the legal system and the rights of the accused. They further argued that if the respondents were deprived of their right to continue with the prosecution, they may be unable to recover damages sufficient to compensate for the full extent of their loss if the inordinate stay of the proceedings pending the revision application is deemed unjustified. In contrast, the applicant could file a civil claim for malicious prosecution if the revision is successful. Consideration of the application. Applying the fundamental principles in Davis, Wesley, Sigire versus Attorney General, Supra, to the current case, the court makes the following determination. 1. Whether the applicant has established a prima facie case. The general rule is that criminal cases should only be held in the rarest of circumstances because the duty to fight crime is a duty that affects the whole country, and therefore criminal cases should be heard seamlessly unless the applicant proves that their right to a fair trial is as laid out in Article 28 of the motion under threat. To get a stop a criminal case, the applicants must demonstrate that they have a advantage. Make a finding under this ground necessitates an inquiry in 2 grounds laid down in revision clause number 2 of 2025. without getting into the case's merits to establish whether the applicant has an arguable revision. For ease of reference, the rest of the revision are reproduced here below. Round 1. The Chief Magistrate illegally and without jurisdiction entertained the applicant's complaint, drew up a charge, and issued summons. Round 9. The Chief Magistrate separately consulted a purported parish chief ward administrator who was finding it did not confirm the response complaint and improperly relied on this consultation. Round 7 and 5. The Chief Magistrate erred in holding that a first case was established against the applicant under Section 115, subsection 3 of the Penal Code Act, CAR 128. He improperly found that the response made the reasonable and probable threshold under Section 42, subsection 3 of the Court Act. Round 10 and 11, the Chief Magistrate wrongly found the respondent's complaint was not vexatious and frivolous. He added in holding that the respondent's complaint was not an abuse of court process. Round 2, the Chief Magistrate improperly failed to dismiss a denied complaint on oath by the intending private prosecutors. Round 6, the Chief Magistrate disregarded Section 6, Subsection 2, Part A, Section 7, Part Subsection 1, Section 7, Section 2, and Section 7, Subsection 4 of the Electronic Transactions Act in considering the response video evidence. Round 8, the Chief Magistrate did not consider the context, symbolism, and constitutional protections of the words in question, thereby occasioning a miscarriage of justice. Round 3, the Chief Magistrate erred in law by denying the applicant's request to cross-examine Yamazima on his affidavit in reply. Round 4, here the Chief Magistrate wrongly concluded that the respondent did not breach the duty of candor. Round 12, the Chief Magistrate improperly declined to excuse himself from the proceedings. The court will now do a systematic audit of the above grounds. Round 1, whether the magistrate illegally and without jurisdiction entertained the response complaint, drew up a charge, and issued summons. This ground raises two questions for court's determination. The first question is to ask under this ground is whether the Chief Magistrate had the power to entertain the response complaint, draw a charge, and issue summons. Section 42, Section 3 to 7 of the Magistrate Act comprehensively sets steps to follow while instituting private prosecution. It provides as follows: 3, 4, 5, 6, 7. The proceedings. The preceding section highlights the procedure for initiating a private prosecution, which was of multiple steps in which a magistrate plays a vital role. Firstly, any individual, excluding public prosecutors or police officers, who believes there is reasonable cause to think an offense has been committed can lodge a complaint with the relevant magistrate. The complaint can be made orally or in writing. If made orally, it must be documented by the magistrate. Upon receiving the complaint, the magistrate must consult the local chief in the area where the alleged offense occurred Although this step might be bypassed if the complaint is accompanied by a letter from the chief, after ensuring the complaint indicates prima facie evidence of an offense and is not frivolous, the magistrate will formalize a charge against the accused. The magistrate then decides whether to issue a summons or a warrant for accused disappearance in court. The law cautions that a warrant may only be issued if the charge is substantiated by sworn evidence. The magistrate also has the discretion to delay issuing a summons or warrant, potentially directing the police to investigate the matter first. The magistrate plays a pivotal role in the private prosecution, acting as the gatekeeper who ensures that only serious and substantial complaints proceed to formal charges. The magistrate's responsibilities, from consulting local authorities to deciding the issues of summons or warrant, help maintain the integrity of the judicial process and prevent the misuse of the system by addressing frivolous or vexatious complaints. Hence, the magistrate ensures that the rights of the accused are protected while providing a pathway for private individuals to seek justice. The record shows that the chief magistrate complied with the law regarding the instant case. This leaves me with the second and last question: whether the chief magistrate had the jurisdiction to entertain the respondent's complaints. The term jurisdiction encompasses a wide range of meanings that vary based on the context in which it is used. According to Black's Law Dictionary, 8th edition, 2004, on page 867, jurisdiction is defined among other interpretations as follows. 1. A court's power to decide a case. 2. A geographic area within which political or judicial authority may be exercised. And 3. A political or judicial subdivision within an area. In Consultation Moses versus Katongole Singh, Marak, and another, Kampala election petition number 23 of 11, court held that the term of jurisdiction is not a term of art. It is a term of law. It is a term of very extensive legal import. It embraces every kind of judicial action. It confers upon the court the power to decide any matter in controversy. It presupposes the existence of a duty constituted court with full control over the subject matter and adjudication. It also presupposes full control by the court of the parties to the subject matter under investigation by it. Jurisdiction defines the power of a court to inquire into facts, to apply the relevant law, to make decisions, and to declare the final outcome of the subject matter under its inquiry. In Ahmed Kawoya Kangu versus Bang Abu Fred and another Supreme Court super application number 4/2007, Justice Bat Katrebe, then Justice of the Supreme Court, held that jurisdiction of the court is not a matter of implication, but must be prescribed by law. In this context, I interpret jurisdiction to signify 1. The authority of a court to adjudicate a case, and 2. A specific geographic region where judicial power can be exercised. In paragraph 5 of the complaint of oath, the applicant is said to have committed the offense of insulting the modesty of a woman contrary to section 115, subsection 3 of the Penal Code Act. In the same paragraph, the complainants alleged that the offense was committed at Katonga Road in Kampala, Central Kampala. The response complaint. The authority of a chief magistrate to adjudicate cases is provided for in section 161, subsection 1, part A of the Magistrate Court Act, which permits the chief magistrate to handle any case, excluding those that carry the death penalty. The alleged violation pertains to section 115, subsection 3 of the Penal Code Act, which prescribes a penalty of 1 year's imprisonment. This offense falls within the subject matter jurisdiction of the Chief Magistrate Court. Touching on the issue of geographic jurisdiction, item 14 of the schedule in the Magistrate Court Magistrate areas, instrument 2024, shows that the magistrate areas with jurisdiction at Uganda Road, a grade 1 magistrate at Uganda Road, a grade 1 magistrate at City Hall, and a grade 1 magistrate at Law Enforcement Center. Because of this, the matter of geographical jurisdiction is satisfied. Based on the above, it is evident that the subject matter and geographic jurisdiction align with the powers conferred upon the Chief Magistrate Court. Firstly, as outlined in section 161, section 1, part A of the MCA, chief magistrates are empowered to adjudicate cases that do not carry death penalty. The alleged offense carries a maximum penalty of 1 year's imprisonment, which is within the subject matter jurisdictional limitations of a chief magistrate court. Secondly, the issue of geographical jurisdiction is also satisfied. The alleged offense was said to have occurred on Katonga Road in central Kampala, which falls under Central Division. The Chief Magistrate has the authority to preside over offences committed within this area. Under this, the trial Chief Magistrate has the requisite jurisdiction to consider the complaint on oath filed by the respondent. Ground 9. The Chief Magistrate separately consulted a purported parish chief, stroke ward administrator, who was finding not confirm the respondent's complaint and improperly relied on this consultation. Section 42, subsection 4 of the Magistrate Court Act provides that, I quote, for upon receiving a complaint under subsection 3, the magistrate shall consult the local chief. Emphasis. Magistrate shall consult the local chief of the area in which the complaint arose and put on record the gist of that consultation. But the complaint is supported by a letter from the local chief. The magistrate may dispense with the consultation and thereafter put that letter on record. The excerpt above says that upon receiving a complaint, a chief magistrate is required to consult with the local chief of the area where the complaint originated. This consultation is intended to gather insights or opinions from a local authority regarding the complaint. The magistrate must then document this consultation. The requirement for documentation suggests an element of transparency in how complaints are handled. However, it does not explicitly state that this consultation should be public knowledge. See Saint Jabalaba versus Kakande, criminal division case number 2 of 2013, reported In this case, the Chief Magistrate complied with the law by consulting the word administrator. Now, this brings me to the second question: whether the findings from the parish chief word administrator did not conform the response complaint. The record shows that the applicants attached a letter authored by M.S. Kabarungi Elizabeth, the chairperson of Katonga LC1 in Nakasero 1, and directed to the Chief Magistrate of Uganda Road to their complaint under oath. The contents of the letter were as follows. Noted. My attention has been brought to a video recording with utterance by Lawyer Isaac Ssemakadde, the President of Uganda Law Society, insulting the person of the DPP. This is to confirm that the officers of the People Front for Freedom, where the incident is alleged to have taken place, are in my area or jurisdiction. The PFF occasionally holds functions where members of the press attend, including one held on the 18th day of November 2024. The report also indicates that, in compliance with the legal provisions outlined in Section 42, Section 4 of the Mass-Court Act, the Chief Magistrate at Uganda Road issued a letter on January 14, 2025, to the Nakasero 1 Parish Chief, Ward Administrator, requesting for verification of the claims made. Accompanying this letter was some correspondence from the LOC1 chairperson. The Chief Magistrate letter reads as follows. I have received a complaint from court filed by Yamazima Joshua and Tony Tukonde, alleging that Lawyer Isaac Ssemakadde, President of Uganda Law Society, insulted the modest of a woman, A1 late Justice Jane Francis Abodo, the Director of Public Prosecution, when he allegedly referred to her as a vagina from Karamoja, while others members of People's Freedom Front, PPF, on 18th November 2024 at Katonga. The said utterances were recorded on a video. I also received a letter from M.S. Kabarungi Elizabeth, LC1 chairperson Katonga, confirming the same utterances. The same is attached. This letter serves to ask you to confirm as the area local chief whether the said allegations are true. In a response dated January 15, 2025, the parish chief, ward administrator of Nakasero 1, Central Division, Kampala, confirmed that the statements were indeed made. She remarked, I quote, I hereby confirm that the letter dated November 21st, 2024 was written by Kabarungi Elizabeth, the LC1 chairperson of Katonga Zone, Nakasero 1 Ward, which is located in the Kampala Central Division, and the stamp used belongs to Kampala Capital City Authority. She confirmed that the utterances were made, and all the contents of her letter are true, as per the phone calls made to her on 15th January 2025 at 13:21 hours. The above evidence indicates that the parish chief, ward administrator, confirmed the allegations utterances, confirmed the alleged utterances made by the applicant. In the response dated 15th January 2025, the parish chief What the administrator explicitly states that the letter from M.S. Kabarungi Elizabeth, the LC1 chairperson of Katonga, was authentic, and the claims regarding the utterances were true. Her letter also states she verified the truth of the alleged following a phone call to M.S. Kabarungi Elizabeth on 15th January 2025 at 13:21 hours. Considering this evidence, I find the parish chief, ward administrator, verified the statements. Rounds 7 and 5. The chief magistrate argued in holding that a Prima facie case was established against the applicant under Section 115, Subsection 3 of the Penal Code Act, Cap 1 to 8, laws of Uganda. The chief magistrate improperly found that the respondents met the reasonable and proper threshold under Section 42, Subsection 3 of the MCA. If a court sanctions a complaint under oath, it must be satisfied that it conforms to the law. Section 42, Section 5 of the Passport Act states, after satisfying himself or herself that a prima facie case, the commission of an offense has been disclosed, the key consideration is that before a magistrate orders a private prosecution, they must be satisfied that the complaint discloses a prima facie case. Jamil Damulira Mutuzi, an author on the subject of private prosecution, underscores the significance of establishing a prima facie case prior to authorizing private prosecution, as articulated in the following statement. The question of whether a private prosecutor should have a prima facie case because he is permitted to institute a private prosecution has been addressed differently in different countries. In some countries, such as Australia, all applications of this kind, unless the magistrate judiciously applies his mind, or the circumstances in which to grant leave for private prosecution, the danger of victimization and abuse of process is imminent. The essential ingredient of the offense is one such factor that should not be overlooked. Turning to the instant case, the chief magistrate was alive to the requirements of Section 42, Subsection 3 of the Passport Act. On page 6 to 7 of the ruling in Uganda, private prosecution by Yamazima Joshua and the Mukonde versus Isaac Ssemakadde, case number 913 of 2024, is stated as follows. The prima facie case under Section 42 of the MCA is for court to establish as to whether the commission of an offense has been disclosed and that the complaint is not frivolous or vexatious. The complainant alleges that the alleged utterances amount to an offense under Section 115, Section 3 of the PCA. Section 115, Section 3 of the Penal Code Act states, and a person who, intending to insult the modesty of any woman or girl, utters any word, makes any sound or gesture, or exhibits any object, intending that word or sound shall be heard, or that the gesture or object shall be seen by that woman or girl, or intrudes upon the privacy of that woman or girl, commits a misdemeanor and is liable to imprisonment for a term of 1 year. For a prima facie case to be made out with regard to the offense of insulting the modesty of a woman, the following reasons must be seen to exist. 1, A person utters any word, makes any sound or gesture or exhibits any object. 2. He or she does so with intent that that word or sound shall be heard or that the gesture or object shall be seen by that woman or girl or intrudes upon the privacy of that woman or girl. 3. The intention to insult the modesty of any woman or girl. 4. It is the accused person who uttered the said words or who made the said sound or gesture. He further stated. The evidence before this court is of a flash disc with a video of the alleged utterances attributed to the intended accused, and a transcription of the same, of which both were annexed to the complaint. I have had the opportunity to play the video, the said video, on the flash disk. I have also read the transcription of the utterances on the said flash disk made by Uganda Broadcasting Corporation. In the said video and transcription, a male voice is heard saying, all this was like your particular carefully is then given legal addressing by this from Karamoja. I have made a case before that you have a pumpkin or a DPP, but some lawyers continue to pretend that she is actually a DPP, and for some they take it very seriously because they think it is an attack on womanhood, or it is an attack on being a Karmajon. That is an absolute nonsense. She's a pumpkin. She's dead wood. She's a dim wing. She's a careless, shameless, careless. She's a to go in the nest of our criminal justice. The male voice in the above court was referring to a director of public prosecutions. Uganda has one DPP, Honorable Justice Jane Francis Abodo, who is a woman, and she comes from Karamoja. It is most likely that she is the person referred to in the above video. In the said video, the male voice is heard referring to the DPP, a woman, has a vagina from Karamoja, a pumpkin, deadwood. In their primary meaning, the above words are offensive, and if directed to a woman, they amount to insulting her modesty. It follows therefore that whoever made such utterances at a public gathering in the presence of media intended that Honorable Justice Jane Francis Abodo would hear the same utterances. Anyone who refers to a woman by her private body parts intends to insult her modesty. Anyone who refers to a woman as from Karamoja, Deadwood, etc., at a public gathering, well aware that there is a media presence, know that the said woman will definitely hear those words against her. The intention is most likely to insult her modesty. The person in the video has been identified as Isaac Ssemakadde, the president of Uganda Law Society. When his advocates appeared in court on 4th December 2024, they did not dispute the allegation that was their client in the video. The argument was that Honorable Justice James Samodo had not complained yet. This case is victim-centered. The victim, the evidence on record is, as alluded to in the Chief Magistrate's Court ruling, indicate that prima facie, the necessary elements of the offense of insulting the modesty of a woman were established. Below is a breakdown of how each ingredient is satisfied. Utterance of words, sounds, gestures, or expression of objects. There is evidence that a person uttered derogatory terms and phrases directed to a woman in a video recording. To intend for the words or sound to be heard. There is evidence that the remarks were made at a public gathering with the media present. The setting and presence of media indicate a clear intent to broadcast those statements beyond a private conversation. The strategic choice to articulate the remarks in a forum where they would be recorded and disseminated underscores the likelihood that they are chosen so to express his views and ensure they reach the victim's ears. The intention to insult modesty. When given their ordinary meaning, the language used is offensive and demeaning and serves no constructive purpose other than to inflict emotional harm and degrade in a public setting, wherever they intended for. For, are chosen as the originator of the remarks. It has been established that Isaac Ssemakadde is the individual making the remarks in the video. And his advocates did not dispute this identification in court. The Chief Magistrate ultimately concluded that a prima facie case for the alleged offense was established as all essential elements were evident. I will now deal with the issue of reasonable and probable cause. Section 42, Section 3 of the MCA provides that a person other than a public prosecutor or a police officer who has reasonable and probable cause to believe that an offense has been committed by any person may make a complaint of the alleged offense to a magistrate and has jurisdiction to try or inquire into the alleged offense, or within the local limits of whose jurisdiction the accused person is alleged to reside or be. Every such complaint may be made orally or in writing, signed by the complainant, but if made orally, shall be reduced into writing by the magistrate, and when so reduced, shall be signed by the complainant. This section empowers individuals, private citizens, prosecute crimes they believe have occurred. It specifies that any person, except for public prosecutors or police officers, who believes an offense has occurred, has the right to make a complaint. The individual, however, must have reasonable and probable cause for believing that an offense has been committed. It does not matter whether an individual is the victim or not. All that the same individual is required to have are the disparate reasons or evidence.
Your Honor is seeking evidence, whether that is the ruling for the slow execution or the main application to distribution. Number 30 is the application for slow execution.
I'm reading, as I said at the beginning. Were you not hearing? You will check the report after. Don't distract court. This section empowers an individual, private prosecutor, private citizen to prosecute claims they believe have occurred. It specifies that any person, except for public prosecutors or police officers, who believes an offense has occurred has the right to make a complaint. The individual, however, must have reasonable and probable cause for believing that an offense has been committed. It does not matter whether an individual is the victim or not. All that the said individual is required to have are legitimate reasons or evidence to suspect that a crime has taken place. The operating phrase in the above section is reasonable and probable cause. In Amina Pimbi versus Ramadan Kiwe, probable and reasonable cause was defined as quoted, an honest belief in the guilt of the accused, based on a full conviction, founded upon reasonable grounds of the existing state of circumstances, which, assuming them to be true, would reasonably lead an ordinary, prudent, and cautious man placed in the position of the accuser to the conclusion that the person charged was probably guilty of the offense imputed. The phrase reasonable and probable cause means the individuals should have legitimate reasons or evidence to suspect that a crime has taken place. This requires more than mere suspicion. Some level of evidence or support for the belief is necessary. In the instant case, the private prosecutors presented evidence alongside their complaint, specifically a flash drive containing a coding of the alleged utterances contravening Section 115, Section 3 of the Penal Code Act, and a transcription from the Ghana Broadcasting Corporation. The Chief Magistrate Judicial Stable considered the statement under oath and consultation with the ward administrator, and found that the complainant had made the expression of a reasonable and probable cause before ordering the prosecution. Round 10 and 11. The Chief Magistrate wrongly found the respondent's complaint was not facetious and frivolous. He argued in holding that the respondent's complaint was not an abuse of court process. Section 42, Section 5 of the Magistrate Act provides, after satisfying himself or herself that prima facie the commission of an offense has been disclosed, and that the complaint is not frivolous or excessive, under this ground, the court is more interested in the phrase, and the complaint is not frivolous and excessive. This part of the section is that the complaint should have merit and not be based on unsupported accusations or intended merely to cause trouble. In his affidavit supporting this application, the applicant asserts that the respondents have initiated several lawsuits against him in bad faith, clearly misusing the court process, and in blatant abuse of court process, seeking further harass him by commencing a baseless private prosecution. The fact that a private prosecutor is bringing proceedings or civil proceedings are concurrent or remain an option and irrelevant consideration, save where improper motive is concerned. For an accused in private prosecutions to raise the issue of the improper motive of the prosecution or prosecutor, they should ordinarily be able to establish that 1. The private prosecutor is pursuing a personal vendetta against them. If instituted, the civil suits are in a way related to the criminal one. 3. The prosecution is purely out to achieve financial redress rather than a means to obtain punishment for criminality. In the instant case, I find no evidence on record demonstrating that the private prosecutors have personal vendetta against the applicant. I also find that the applicant has not proven that his prosecution is solely motivated by the desire for financial redress rather than to obtain punishment for criminality. Through his pleadings, I find that the respondents have filed 2 civil matters. However, although these 2 matters are civil, they are not connected to the criminal matter filed by the respondents. These civil matters concern the expulsion of the Attorney General and Solicitor General from Uganda U.S. Council via Order RND number 1 of 2024. The current criminal matter involves insulting the modesty of a woman. The applicant claims that the matters were withdrawn, but provides no evidence. If the 2 matters are still in court, the civil court will determine whether the respondents had the necessary locus standard to file those matters. In doing so, the issue of whether they rigorously abused the court process will be adequately addressed. If they were withdrawn, as suggested by the applicant, he is welcome to seek damages in the civil court for malicious prosecution. What this court will not do is to infer abuse of court process without concrete evidence. Round 2. The Chief Magistrate improperly failed to dismiss a denied complaint on oath by the intending private prosecutors. The scenario that gave rise to this ground can be likened to a witness giving evidence in chief, being cross-examined, seeming to contradict themselves, and offering clarification during re-examination. Paragraph 5 of the affidavit in support to provide criminal witness application number 87 of 2024 states, I know that on 22nd November 2024, a cantankerous couple of mischievous advocates, Yamazima Joshua and Tony Tumukunde, filed a complaint on oath seeking summons for my appearance to plead to a proposed charge of insulting the modesty of a woman, to it, M.S. Jane Francis Abodo of Karamoja. Contrary to Section 115, Subsection 3 of the Penal Code Act. In paragraph 7 of the affidavit in reply, Joshua Yamazima deponed upon what seemed like a denial of the complaint on oath, if read in isolation of the entire affidavit. The deposition stated that the contents of paragraph 5 to 26 of the applicant's affidavit are denied in total, and the applicant shall be put to strict proof thereof. However, if the entire affidavit is read, it becomes clear that the complaint on oath was not denied. Paragraph 9 states, I know the complaint on oath in KLA 00CRCO 0913 2024 is competently before the court, having complied with all the preliminary requirements. And of course, I find that Joshua Yamazima did not deny his complaint on oath, despite what might appear to be a denial when looked at in isolation from the entire affidavit. In paragraph 7 of the affidavit in reply, Joshua states that he denies the contents of the applicant's affidavit, including the complaint in total, which would be interpreted as denying the complaint. However, when taken in the context of the entire affidavit, including paragraph 9, it becomes clear that he acknowledges the existence of the complaint, of course. In explicitly saying, I know the complaint on oath in KLA, that's 00, that's CR, that's CO, that's 0913, that's 2024. The respondent is, in essence, indicating that they know the particulars of the sworn complaint, related that's the case number allocated the matter involving legal allegations or claims. In saying, is competently before court, the respondent admits that the complaint has been adequately filed according to legal procedures and is under the court's jurisdiction. So, while he may deny the specific allegations or claims outlined in the application, it does not deny that the complaint exists and is legally in the court system. Ground 6. The Chief Magistrate disregarded Section 6, Subsection 2A, 7, Subsection 1, and 2 and 4 of the Electronic Transactions Act in considering the respondent's video evidence. For ease of reference, I will reproduce the law. Section 6, Section 2A, Section 7, Section 1, 2, and 4 of the Electronic Transactions Act, Cap 99, provides, as it provides. Without going into the merits of the case, ensure that electronic communication can be organized and evaluated in judicial proceedings is essential. So, when does the electronic evidence become admissible? During investigations or trial? Electronic evidence is admissible when it is authenticated and meets the rules of evidence, typically at the trial stage. During the preliminary phase of a private prosecution, evidence is used to establish a 21st case, meaning it must raise a presumption of fact unless contradicted by other evidence. This evidence does not need to be conclusive, but should provide a reasonable basis for the claims made. At this stage, the focus is on whether sufficient evidence exists to proceed rather than securing a conviction. In the current case, since the trial had not commenced, the Chief Magistrate was not required to adhere to the admissibility criteria for electronic evidence. His only obligation under Section 42, Section 5 of the Magistrate Act was to determine if the available evidence would raise a presumption of fact, which he successfully fulfilled. Ground 8. The Chief Magistrate did not consider the context, symbolism, and constitutional protections of the words in question, thereby occasioning a miscarriage of justice. I will first deal with the issue of failure to consider the context and symbolism of the words in question. The first, often considered the primary rule of interpretation in literal rule, is the literal rule. Under this rule, words are interpreted based on their plain, ordinary meaning, without developing into other excesses like context, symbolism, intent, or purpose. When using this rule, the court's only role is to ascertain the meaning of the words in their common every edition, as seen on page 7 of his ruling, via case number 913 of 2024. I quote, in the said video, the male voice is heard referring to the DPP, a woman, as a vagina from Karamoja, a pumpkin, dead wood, a dimwit. In their primary meaning, the above words are offensive, and if directed to a woman, they amount to insulting her modesty. In my view, I find that even an ordinary bystander, having given the words in question their ordinary meaning, would have come to the same conclusion, that the words were offensive. If the applicant wanted to benefit from the other two rules of interpretation, The golden rule and mischief rule. He owed it to himself to appear before the court when summoned, and if put on a defense, explain the context and symbolism of the words in question. Then the court would have something to consider. From an outsider's perspective, the applicant wants to use revision to circumvent the procedure. I will now turn to the issue of failure to consider the constitutional protection of the words. Article 29, Clause 1A of the Constitution guarantees freedom of speech and expression. This right is fundamental to the foundation of a democratic society, enabling individuals and activities related to freedom of speech. Therefore, speakers must understand the boundaries set by law before engaging in any speech. Of suspect interest, in this case, Article 43, 1 and 2, Part C of the Constitution, Article 24 of the Constitution, Section 115, Subsection 3 of the Penal Code Act. Article 43 is reproduced, Article 24 is reproduced, and Section 115, Subsection 3 is reproduced again here by the land judge. When read together, the above provisions of the law show that while individuals in Uganda are entitled to speak freely, the prevailing legal environment indicates that such freedom exists within a framework of caution and compliance with the complex web of laws meant to protect various interests. In this particular case, within the context of the ordinary meaning, dehumanizing words which serve no constructive purpose other than to inflict emotional harm and regret were allegedly said in a public setting with media present. The words were directed to a woman. The remarks, having been allegedly said to a public gathering, at a public gathering with media present, indicate a clear intent to have the statement recorded and disseminated with a likelihood of reaching the victim's ears. Considering this, the applicant could, on the face of it, be said to have committed a misdemeanor under Section 115, Section 3 of the Penal Code Act. Contravened Article 43 of the Constitution by violating the fundamental human right of a woman he is alleged to have insulted, that are also protected under Article 24 of the Constitution. For the court to regard the said words as protected, it must evaluate whether they fit within the acceptable and demonstrably justifiable category as outlined in Article 43, 2C, determine whether words are constitutionally protected is inherently contextual. The court cannot indiscriminately classify any words or particularly those deemed offensive as constitutionally protected without proper context. The applicant has failed to provide this necessary context despite being called upon. Consequently, he cannot fault the Chief Magistrate for not recognizing them as constitutionally protected. Counsel, my duty is to pronounce the ruling, and you are not.
We intend to arrest the ruling because you have said
before the judge, my duty is to pronounce it, and I pronounce it. Don't disturb.
Your Worship, I'm not disturbing.
Round 3. The Chief Magistrate erred in law by denying the applicant's request to cross-examine the Amazima on his affidavit in reply. Get to know that this, I'm just a registrar assigned to perform a particular duty, and it must be done. It's my duty. Once I fail, I have failed myself, and I will not sit as a registrar. So, abide by that. The rest you continue with the current judge. Okay? The right to cross-examine witnesses, including a private prosecutor, is a fundamental aspect of a fair trial, ensuring that the accused can challenge the evidence presented against them. However, under Section 1 of the Evidence Act, cross-examination of an affidavit reply is at the discretion of the court. Section 1 of the Evidence Act provides that this act shall apply to all judicial proceedings in or before the Supreme Court, the Court of Appeal, the High Court, and all courts established under the Master Court Act, but not to affidavits presented to any court or officer, nor proceedings before an arbitrator. The Act is intended to govern the proceedings in the specified courts while explicitly excluding certain legal documents, affidavits, and alternative dispute resolution processes, arbitration. By virtue of this, the court may exercise its discretion to allow cross-examination depending on particular factors of each case. Some of the things the court can consider before exercising its discretion include the following. 1, the nature of the case. 2, whether cross-examination will actually delay the trial or facilitate expeditious disposal. 3, whether the deponent of the affidavit contains facts that are in issue or conflicting evidence. 4, if cross-examination will assist in resolving the issue before the court. In the instant case, the response are said to have denied their complaint of the Chief Magistrate in his ruling, via application number 87 of 2024, found that once the 10 paragraphs of the said affidavit once the 10 paragraphs of the said affidavit reply are read together, Joseph Jamazima cannot be found to have denied filing the complaint. Herein, I have agreed with this finding and subheading round 2. In my view, cross-examination would only unduly delay the trial and would not have facilitated the expeditious disposal of the matter. It, therefore, did not guarantee the court to exercise its discretion. Round 4. The Chief Magistrate wrongly concluded that there was no breach of the duty of candor by the respondent. Paragraph 9 of the applicant's motion, via criminal statute number 87 of 2024, states that the respondent did not make frank and full disclosure to the court and the investigative and prosecutorial authorities. Additionally, paragraph 15 of the affidavit is supported by criminal statute number 83 of 2024. The applicant affirms that the cantankerous couple unjustifiably deprived me of an opportunity to confront the alleged victim on the ingredients of the proposed offense before an independent investigator, thereby violating my constitutional right to a fair pre-trial investigation. I recognize that the legal framework for private prosecution is unclear and well developed. This may taint an accused person's right to a fair hearing under Article 44, Section Part 4 of the Constitution. Part C. It may also hinder a prosecutor's right to successfully prosecute a clever accused person who exploits these loopholes to their advantage through unnecessary, endless objections. In light of this, I find this issue deserving of revision. This would enable the court to interrogate the various problems arising, including disclosures in private prosecution. When are they made? What can be disclosed, and to whom are they made? 2, the right of prospective accused person in private prosecution. 3, the roles and duties of the private prosecutor. 4, the role of the victim. Ground 12. The chief magistrate improperly declined to recuse himself from the proceedings. The applicant contends that the chief magistrate should have recused himself from the trial. The record shows that the chief magistrate considered the request to step down and dismissed it for lack of merit. In light of all the above, except for ground 4, which touches on the right to a fair hearing, I find that the main grounds for revision fronted by the applicant do not raise legitimate issues with a reasonable chance of success if brought to a full hearing. By virtue of ground 4, the applicant has established from my first case whether the applicant will suffer irreparable damage if the application is not granted. The applicant contests that he will suffer irreparable harm and prejudice by undergoing a trial that is prima facie vitiated by fundamental flaws and irregularities. The applicant further asserts that the circumstances have exposed him to adverse publicity, damaging his status, profession, and livelihood, and threats of arrest, detention, conviction, and sentencing on a charge he maintains is unfounded, illegal, defective, and unsustainable. Conversely, the respondent argues that the applicant has failed to demonstrate that he will suffer any loss or injury and cannot be compensated through monetary damages, nor has he shown that such harm is difficult to quantify. This court is in doubt as to whether or not the law shall be irreparable. Considering this, I find that the applicant has failed to prove this ground. Whether the balance of convenience tilts in favor of the application being granted. This fundamental principle is only considered if the court is in doubt of both or any of the first two requirements. Having found that the applicant has a prima facie case, but the court is in doubt as to whether or not they will suffer irreparable loss, the balance of convenience must be considered. To achieve this, I will weigh the potential inconvenience to the applicants against those of harm to the respondents if the stay is granted. Firstly, the applicant argues that proceedings with the lower court's prosecution without a stay would lead to a situation where if the revision application is ultimately upheld, the applicant would be left with a position where their rights and liberty have been impacted unnecessarily. The argument emphasizes preserving the status quo until the revision application is resolved. On the other hand, the respondent asserts that a stay would impede their legal rights and hinder the judicial system's integrity. I acknowledge that the ability to pursue legal remedies is the cornerstone of justice, and an obstruction could set a precedent that undermines the efficiency of the legal process. However, the court must balance the rights of the victim and the accused person so that none should be sacrificed at the altar of justice. The victim and the accused deserve justice. All must have their day in court without unjust roadblocks. Secondly, the applicant highlights the importance of safeguarding personal liberty, which is a fundamental principle of law. By granting a stay, the court protects the applicant's rights, ensuring that any adverse actions taken by the lower court are revisited and assessed for validity. On the other hand, the respondents emphasize that halting proceedings would have serious ramifications for the proper function of the justice system, potentially affecting public confidence in the rule of law. Third and last, the applicant argues that allowing the lower court to proceed would result in irreparable harm to him if the findings were annulled later. A stay would mitigate this risk by halting proceedings while a revision is promptly conducted. The applicant is basically arguing that if the lower court continues with its proceedings and makes findings that are later overturned, it could lead to significant and irreversible damage to him. Therefore, he believes that granting a stay is necessary to prevent this potential harm while a review of the case is conducted. On the other hand, the respondents argue that if the stay were conducted, they would subsequently suffer loss of their rights to prosecute. They may not be able to recover damages sufficient to compensate for the full extent of their loss if they noted stay of proceedings pending revision application were found to be unwarranted. Unlike the malicious prosecution remedy available to the applicant, the response argues that granting the stay would potentially harm their rights to pursue prosecution and that they might not be able to fully recover damages for their losses if the stay is deemed unnecessary. The situation contrasts with the applicant, who can seek a remedy for malicious prosecution. In the scenario presented, the balance of convenience leans towards the applicant for several reasons, despite the valid concerns raised by the respondents. The reasons in favor of granting include: 1. Preservation of the status quo. The applicant emphasizes maintaining the status quo until the revision application is resolved. This argument underscores the need to prevent the potential violation of the applicant's right to liberty that could arise from continuing the local prosecutions. 2. Judicial integrity and the rights of the respondents. While the respondents raise important points about the potential interest of their legal rights and the judicial process, these concerns are primarily about the implications of delays and the judicial system's efficiency. However, the more pressing issue is the protection of individual rights, especially when those rights may be jeopardized. The response claims of harm do not carry the same immediacy or risk of damage compared to those of the applicant concerned. In the interest of justice, I find it justifiable to grant a stay to safeguard the applicant's right to liberty while the revision is underway. This will ensure a fair process for both parties without the threat of serious consequences. Decision. The application is allowed for the following reasons. The applicant has established a Prima facie case. 2. Balance of convenience tilts in favor of the application being granted. Orders. 1. The Chief Magistrate Court of Uganda Road is directed to stay proceedings in Uganda. Private prosecution by Jamazima, Joshua, and Tony Mukonde versus Isaac Ssemakadde. Uganda Road Chief Magistrate criminal case number 913 of 2024. Pending determination of Isaac Ssemakadde versus Uganda. Private prosecution by Jamazima, Joshua, and Tony Mukonde. Criminal revision case number 002 of 2025. The parties are directed to file submissions in the criminal revision case number 2 of 2025 to expedite the revision. The applicant must file his submissions by 23rd of April in the year 2025, while the response must file their reply by 2nd May 2025. And a rejoinder must be filed by 7th May 2025. The court will issue its ruling or not. Signed, Gardenia, Paul, Oliver, George, 10th April 2025.
Everywhere! Arab B.
Yes, madam. Any matter has to be senior